Welcome dear students once again. In today's lecture, we will learn how to draft an application under section 5 of Limitation Act. Before drafting this limitation, I would like to tell you a few fundamental principles of law of limitation. The first and foremost principle of law is that limitation is a negative remedy which is always available against the plaintiff. And if we come back to section 5 of Indian Limitation Act, it says that the prescribed period of limitation according to Indian Limitation Act can be extended on showing sufficient cause, or in other words, the court has power to condone the delay in filing the application or appeal before the court on sufficient ground being shown to the court. And I will tell you in the beginning that this section 5 of Limitation Act is applicable to appeals and applications. This section is not applicable to the suits because the moment cause of action arose in the favor of a plaintiff, there was a long period of say 3 years or 12 years for filing the fresh suit. So this section 5 is not applicable to fresh suits, and similarly this section is also not applicable to execution proceedings. As all of you know that a decree follows after each judgment, and that decree is liable to be executed under Order 21 of CPC. So no extension of time can be availed under section 5 so far as application for execution of decree is concerned. And similarly, dear students, this section is also not applicable before the tribunals. All the proceedings which are to be undertaken before the tribunals, they are not authorized to condone the delay on the ground of sufficient cause being shown under section 5. Now we will start to see how to draft the application for condonation of delay under section 5. So the first point which you must keep in mind, that any appeal or application may be admitted after the prescribed period if the appellant or applicant satisfies the court that he had sufficient cause for not preferring the appeal or application within the prescribed time. There are definite grounds for taking advantage of section 5 of Limitation Act, and the most important ground is sufficient cause to be shown to the court. If the appellant or applicant can show sufficient cause as to why he could not prefer his appeal, why he could not file his application within the prescribed time, then court has power and discretion to condone the delay which occurred in the filing of the appeal or application. So what is sufficient cause, dear students? The sufficient cause in one case may not be sufficient in another case. It all depends on the facts and circumstances of each case. If I may take the example, if you are going to file an appeal and urgently some female member of your family suffered from abortion, you could not file your appeal and you were busy in taking her to the hospital, then this abortion may be a sufficient ground for condonation of delay in filing the appeal. Similarly, if the person who was to file appeal in a civil case, he was punished and imprisonment was ordered against him and he was confined to jail, so again he is not in a position to file the appeal or application before the civil court. So imprisonment may be a sufficient ground for condonation of delay. Likewise, illness, accident, you suffered from an accident, you are confined to bed, you can't approach your lawyer, you can't go to the court. So these are the few examples of sufficient cause being shown to the court. Now in the section 6 itself, an explanation has been added which says that if a party was misled by any order, practice or judgment of the High Court, then in such circumstances, if the party was misled by the order of the High Court while ascertaining or computing the period of limitation, then that misleading order may be a sufficient ground under section 5 for condonation of delay. See, the conclusion is that if applicant or appellant was misled by order or practice of the court in computing the prescribed period, he can claim benefit of section 5. Dear students, this is equally important that Limitation Act and the period of limitation applies only to instituted civil cases and not to the pending proceedings. Pending proceedings means till formation of final decree. The institution of the suit begins with the filing of the plaint. Other party files the WS, case proceeds, judgment is pronounced by the trial court. First appeal may be filed, second appeal may be filed, appeal before Supreme Court may be filed. So during pendency of these proceedings, the limitation is not applicable. Limitation applies only to the instituted civil cases and not to pending proceedings. If a plaint has already been filed in the court, so no question of limitation arises. But if the plaint is returned and it is filed again, then position may be different. Limitation will not apply second time. If the plaint was returned to the party for filing it in the proper court, then limitation will not apply second time. Limitation will be applicable when the plaint was filed for the first time before the trial court. And dear students, you must know that this Limitation Act is not applicable to writ jurisdiction of the High Court and Supreme Court. There is no time limit fixed for filing a writ either before the High Court or before Supreme Court. And in criminal matters also, Limitation Act is not applicable because CRPC contains section 467 to 473. These sections are dealing with limitation for taking cognizance by the court. But you see, entry 131 of schedule attached with the Limitation Act gives 90 days time for filing revision. This revision may be a civil revision under CPC or it may be a criminal revision under CRPC. So 90 days time for filing civil as well as criminal revision is mentioned in the entry 131 of schedule attached at the end of Indian Limitation Act. But normally the Limitation Act is not applicable to criminal matters and Limitation Act is also not applicable to writ jurisdiction of the High Court and Supreme Court. Another important aspect, dear students, of Law of Limitation Act is that if the suit of the plaintiff is barred by law of limitation, then it extinguishes the judicial remedy only and not the right. Your right stands as it is, but you can't obtain judicial remedy from the court of law. The Act has one exception also, where not only your judicial remedy is extinguished, but your right is also extinguished. If somebody has forcibly and openly taken possession on your land or your house, and you have not filed any suit of ejectment against such person for 12 years, so at the expiry of 12 years, your judicial remedy of taking back possession is destroyed, and at the same time, your ownership is also destroyed. The other party acquires ownership by adverse possession. So section 27 of Limitation Act is an exception to this rule that limitation extinguishes the judicial remedy and not the right. But see, only judicial remedy is barred after period of limitation. Extrajudicial remedies are always open, like mediation, conciliation, punch decision in a village or community, or decision of a biradari, or mutual settlement, even if your judicial remedy is barred, by limitation, all these remedies are open and available to you. You can go for extrajudicial remedies if the judicial remedy has become barred because of law of limitation. Dear students, the law of limitation is based upon two Latin maxims. The first maxim says that interest of the state or public requires that a period or limit should be placed to litigation. There should be some limitation how long other party will wait for your suit or for your appeal or your application. Or in other words, you can say that interest of society as a whole, the litigation must come to an end. There has to be some ending to the litigation. And the second principle is that law assists only vigilant litigant and not to those who sleep over their rights or those who are careless about their rights. If I am careless about my ownership, somebody has taken possession of my building and I have not filed suit for 12 years. What I was doing for those 12 years, I was sleeping over my right. So law will not assist me because I kept sleeping for 12 long years. So law assists only those who are vigilant. So dear students, the Limitation Act has a schedule at the end of the act and it gives you period of limitation. There is a long table given at the end of the act which prescribes period of limitation and that limitation is given in the schedule. If you add all possible extensions in the period of limitation fixed by law, then you are reckoning prescribed period. So our equation here is period of limitation as fixed in the schedule plus all possible extensions from section 4 to 24 of Limitation Act is equal to prescribed period. This meaning is given in section 2 clause J also, that there is a distinction between period of limitation and prescribed period. So if I may conclude this equation, period of limitation is the period as fixed in the schedule. It is a smaller period, there is a line before you. Whereas prescribed period, after adding all the extensions, is longer. The line is longer. So prescribed period will always be longer than the period of limitation fixed by the schedule. And dear students, once again I will tell you, we are going to learn how to draft an application under section 5 of Limitation Act. And you have seen that if you have sufficient cause, you have shown the sufficient cause with evidence to the court, so the time may be extended, or delay in filing your appeal or application may be condoned. But mind it, this condonation of delay, extension of time is always discretionary. It is not the right of the party to have condonation of delay every time. Why? The reason. There is a reason. When period of limitation of filing an appeal, say for example appeal, the period of limitation has expired, then the degree holder who has won the case has obtained a benefit under law of limitation to treat the decree as beyond challenge. And this legal right which is accrued to the decree holder by lapse of time should not be lightly disturbed by showing a few causes here and there, and you want to file an appeal by showing few causes. So the decree holder has an accrued right, but at the same time the opposite party could not file its appeal before the court in prescribed time, So court will hear both the parties, whether the cause shown is sufficient or not. And dear students, I may tell you that it is the duty of the court to apply law of limitation and dismiss the suit under section 3 of Limitation Act, even if it is not pleaded in the written statement. It is absolute and mandatory, even at the appellate stage. It is the duty of the court to dismiss the suit if it is beyond the period of limitation. And then another important point is that Limitation Act always operates retrospectively. It applies to those facts and those cause of actions only which accrued before the act came into existence. Meaning thereby, the act applies to past transactions which have already been completed or already been done. And dear students, the period of limitation, which is fixed by law, which is fixed by Limitation Act, cannot be extended or cannot be reduced by the agreement of the parties. Because any agreement, as you know, you have read Indian Contract Act in your first year, that any agreement which is against the law or which defeats the policy of law is void. So suppose the period of limitation of filing an appeal against a particular decree is 30 days. And parties have agreed to reduce this period to 10 days. No, you cannot do it. Or parties have agreed to extend this period of 30 days to 40 days. This is also not allowed. All such agreements are void. You are not at liberty to disturb or to change the period of limitation fixed by the act. And in the beginning, I told you that law of limitation is a negative remedy, and in its operation, depriving a person of power which he possessed before. Right to file a suit. If my right to filing a suit has already been expired, I was not vigilant throughout the period of limitation which was to be counted from date of cause of action. So this Limitation Act is applying against me as plaintiff, that if I have not filed suit for the long period starting from date of cause of action till the date of expiry of the period of limitation, say 3 years or 12 years, so it goes against me. So entire Limitation Act is a negative remedy which operates only against the plaintiff. And this law of limitation is partially substantive and partially procedural in nature also. And the sections relating to acquisition or losing of rights by prescription are substantive in nature. I told you that the exception to the rule is contained in section 27. Rule is that Limitation Act bars only the remedy, not the right. But section 27 is an exception, that after 12 years of adverse possession, the remedy as well as the right of the plaintiff both are lost. So the law of limitation is partially substantive in nature and partially procedural in nature. And if you see the language of section 5, that the court has power to condone the delay if sufficient cause is being shown. So this language shows that filing of an application under section 5 is not necessary for condonation of delay. Court suo motu can exercise the powers under section 5 even in the absence of any application which we are going to draft today. Court has power to extend time even if the appellant has not filed any application before the court. Now, what is sufficient cause, which is the main thrust of section 5 of Limitation Act? Sufficient cause here means a cause which was beyond the control of the party who is invoking the aid of section 5. If I met with an accident, I was confined to bed, I was admitted in hospital for a month or so. So the circumstances were beyond my control. I could not file the appeal in time. I could not contact my advocate. Hence, sufficient cause in nutshell means a cause which was beyond the control of the party. And not only this, when you are going to show sufficient cause before the court for condonation of delay, you will have to explain the delay covered by the period between the last day prescribed for filing of the appeal and the day when the appeal was actually filed. Each and every day has to be explained as to why you could not file your appeal or application from the date of last day of limitation and the day when actual appeal was filed. You will have to explain each and every day in between these two dates. Say for example, we discussed it earlier also that entry number 131 of schedule attached to the Limitation Act provides 90 days time for filing a revision in criminal matters under CRPC. Hence, Section 5 would apply to criminal revisions, and delay in filing criminal revision can be condoned under Section 5 if sufficient cause is shown for the delay. But the condition is same. You will have to explain the delay of each and every day between the last day fixed for the limitation and up to actual filing of the appeal. What was the reasons? You will have to explain it day to day. Similarly, dear students, this Section 5 is equally applicable to criminal appeals also. To sum up, if I may summarize the principles on the basis of which application under Section 5 can be allowed, the principles are as follows. Number one, the party seeking the relief has to satisfy the court that he had sufficient cause for not preferring the appeal or application within the prescribed time. This is the first condition. Second is that this explanation has to cover the entire period of delay. Entire period of delay has to be explained day to day. Then third principle comes out to be that a litigant should not be easily permitted to take away a right which has accrued to his adverse party by lapse of time. Yes, I told you that degree holder has acquired an right by lapse of time, that well, now his degree is beyond challenge. But the other party has shown sufficient cause before filing appeal. So both the parties are to be heard, and court has to weigh the convenience and inconvenience of both the parties. Of course, the degree holder has a accrued right in hand because of lapse of time, but at the same time, the party who has lost the case and wants to file an appeal, his grievances should also be heard. So, fourth and the first important principle, that the proof of sufficient cause is a condition precedent for the exercise of the discretionary jurisdiction. Only after this proof, court has to inquire whether in its discretion it should condone the delay or not. So sufficient cause is a condition precedent. When this discretion is vested in the court, this discretion is a judicial discretion. It's not arbitrary, and it must be exercised to advance substantial justice between the parties. Sometimes, dear students, you will see that one of the party to the civil litigation is a government. So the law says no liberal view should be taken merely because the defaulting party is government, because all are equal before law. As you have read Article 14, equality before law in our constitution, maybe the government or maybe the ordinary litigant, all are equal before the law. So no liberal view should be taken merely because the defaulting party was a government. And the converse of sufficient cause being shown for condonation of delay is that delay cannot be condoned when there are laches on the part of the litigant. If litigant is not If the litigant is not aware of his rights, he is delaying the matter, he himself is following the laches, then delay cannot be condoned, because the Limitation Act helps only a vigilant litigant, not the sleeping over litigant. Sometimes you will see that there is negligence on the part of the advocate, and generally this plea is taken in the courts that it is not the fault of the litigant but fault of the advocate, and because of the fault of advocate, appeal could not be filed in time. So court has to see whether the mistake of the advocate was bona fide or not, or was it merely a device to cover ulterior purpose, that is laches on the part of the litigant. So court has to come to a conclusion that even if it is a negligence of the advocate, it should be bona fide. Only then it will constitute a sufficient cause. And the last point, which I told you earlier also, that each and every day's delay is to be explained before the court. Now we start drafting of an application under section 5 of Limitation Act. This I have taken two illustrations in this exercise, in this lecture. The first illustration is before you, where we will learn application under section 5 of Limitation Act 1963 for condonation of delay. So the first of all, the first principle of drafting is that suppose you have filed your appeal in the court of district judge. So naturally, the application under section 5 of Limitation Act is also to be moved along with memorandum of appeal in the court of district judge. So the first line, as you have seen in the drafting of plaint and WS also, first line is the name of the court where you are going to file your application. So this is in the court of District Judge Noida, District Gautam Buddha Nagar. The matter was decided by Civil Judge Junior Division. You are filing a suit, you are filing an appeal against the judgment passed by the trial court in suit. So first appeal goes to the court of District Judge Noida. So the application under section 5 of Limitation Act for condonation of delay has to be moved before the court of District Judge Noida or District Judge Noida, District Gautam Buddha Nagar. Then you will write down civil appeal number of 2017. Then name of the appellant. Who is the appellant? A, son of B, resident of 906 Designers Park, Sector 62 Noida, District Gautam Buddha Nagar, UP is the appellant. He was the plaintiff in original suit also. We are taking the same facts and proceeding to learn the drafting at length with the help of one illustration, that is specific performance of the contract. So this is the name of the appellant. Then versus who is the second party? X, son of Y, resident of 52 Lajpat Nagar, New Delhi. This is the address of respondent, that is opposite party. Opposite party in appeal is known as appellant. First party is known as appellant and the opposite party is known as respondent. Center heading is application under section 5 of Limitation Act 1963. Like you had put center heading while writing a plaint, you have given a center heading while drafting WS also. Likewise here also you will write down center heading is application under section 5 of Limitation Act 1963 for what you are filing this application? For condonation of delay. This means that your time fixed for filing an appeal has already expired and now you are going for you want to gain extra time which you have already utilized on the grounds of sufficient cause being shown to the court. So this is an application under section 5 of Limitation Act 1963 for condonation of delay. The opening line of this application will be, the appellant named above most respectfully submits as under. This is the opening line. What plaintiff is going to submit, what appellant is going to submit, that the plaintiff appellant had filed a suit for specific performance of the contract before the learned lower court, and the lower court was pleased to dismiss the original suit of plaintiff on 1st July 2017 on merits. The first ground mentioned in this application is that the suit of the plaintiff, suit of the appellant, was dismissed by the trial court on merit on 1st July 2017. Then after losing the case, the plaintiff wants to file an appeal. And for filing appeal, as you know, according to provisions of CPC, a certified copy of the judgment and decree of the lower court has to be filed along with memorandum of appeal. So the second fact which is to be mentioned in the application under section 5 is that the appellant applied for certified copy of the judgment and decree passed against the plaintiff appellant on 1st July 2017. See how now he is vigilant. He has applied for certified copy of the judgment and decree on the very day when judgment was pronounced and the suit of plaintiff was dismissed. But the office of the court usually takes time in preparation of decree and then preparation of certified copies. According to CPC, the decree must be prepared within 14 days of pronouncement of the judgment. So in this case also, the judgment was pronounced on 1st July and the decree and the certified copies were delivered to appellant on 15th July. See, this in this 15 days, the appellant or plaintiff is not at fault because he moved the court for obtaining the certified copy of the judgment and certified copy of the decree on the very day when his suit was dismissed. But 15 days were taken by the court staff or the office of the court in preparation of certified copies. So this period stands excluded from the period of 30 days which is prescribed for filing an appeal before the court of district judge. Now, after obtaining these certified copies, the plaintiff contacted his counsel and got the memorandum of appeal prepared because the losing plaintiff now wants to file an appeal before the court of district judge. So the counsel for appellant called him for signing the documents and filing of appeal on 30th July 2017. Well, counsel is justified. He is calling his client on 30th July because limitation starts from 2nd July. The date of judgment has to be excluded from reckoning of the period of limitation. So period of limitation of 30 days will start from 2nd July and it will end on 31st July. So counsel is ready to file the appeal a day before, that is 30th July 2017. He has called his client that please come and sign the required documents so that appeal may be filed on 30th July 2017. Now, the appellant is also vigilant. On 30th July, the appellant was about to go to District Court Compound, Noida, Gautam Buddha Nagar. But what happened? That his pregnant wife started bleeding due to premature abortion. See the seriousness which the appellant is facing. He was supposed to go to his counsel for filing appeal, but unfortunately, his pregnant wife started bleeding due to premature abortion. And the wife of the appellant fell unconscious. And she was taken to Fortis Hospital, Noida by the appellant after calling an ambulance. And in the Fortis hospital, the doctors performed an immediate operation, but the life of the baby could not be saved. However, the wife of the appellant was saved by grace of God. So the appellant, who was to meet his lawyer for filing an appeal against the judgment dated 1st July 2017, had no option. He could not go to the court because the urgency was that his wife was seriously ill. And finally, the wife of appellant was released from the hospital on 25th August 2017 after hospitalization of say 27 days. This is the emergency which the appellant is facing. So this must be mentioned in the application, that what happened with the appellant, why he could not go to his advocate, why he could not file appeal in time. Now when the wife of the appellant was released from hospital on 25th of August, next day somehow he reached the office of his counsel, ABC advocate. He reached his office next date, that is 26 August 2017, and requested him to file an appeal against order and judgment dated 1st July, passed by the London lower court. And the applicant signed all the documents as directed by his counsel, and accordingly appeal, that is memorandum of appeal, along with this application under section 5 of Limitation Act is being filed before the court today, that is 26th of August 2017. Now you see, there is no mistake on the part of appellant, but this fact you will have to mention in the application, that the appellant has not committed any mistake intentionally in late filing of this appeal. See, the appeal is filed on 26 August. Period of limitation was 30 days, and 30 days has already expired. Even if you exclude the time taken in certified copies, that is 15 days from 1st July to 15th July. Even if that period is excluded, still the appeal is time barred because it is being filed on 26 August 2017. So you must mention these facts in your application under section 5 of Limitation Act, that the appellant has not committed any mistake intentionally in late filing of this appeal, but he was prevented from filing this appeal before this honorable court because of reasons beyond his control, on account of accidental abortion of his wife, and the plaintiff was not in a position to move from the hospital during the period starting from 30th July 2017 to 25th August 2017, that is 27 days period approximately, on account of illness of his wife. This is the sufficient ground which he is showing to the court. And in additional factors which the appellant is writing in this application is that there is no other adult member in the family of appellant who could have taken care of filing this appeal in time, since the appellant and his wife live away from their parents in connection with their services in Noida. The parents of appellant and his wife are resident of Mumbai and are old and infirm persons. Because the court might ask this question from the appellant that, well, if you were busy with your wife in the Fortis hospital, your father, your brother, or any other adult member could have approached the council and the council could have filed the appeal. But he says, no, there is no other adult member. Their parents are living in Mumbai and they are also old and infirm persons. Now the appellant is pleading, you are supposed to mention this fact in your application, that the appellant has shown sufficient cause for not filing this appeal before this honorable court within period of 30 days from the date of impugned order. The period of limitation, as I told you, is 30 days for filing first appeal before the court of district judge. So the appellant is saying, appellant is pleading that appellant has shown sufficient cause for not filing this appeal before this honorable court within the period fixed by Limitation Act. That is the period of 30 days to be counted from the date of impugned order. And as I told you earlier, the date of judgment has to be excluded from counting the period of limitation. Why date of judgment is excluded? Suppose sometimes the judgment is pronounced at 5 o'clock in the evening. So that day is already gone. So law is justified by saying that the date of judgment shall be excluded when you count down the period of limitation and the date of filing appeal. Now you have shown the sufficient cause, but what is the proof that your wife was admitted? Wife of appellant was admitted in the Fortis Hospital, Noida. What is the proof? You will have to mention in the application, and you are supposed to file those documents also before the court to show your sincerity and to substantiate your point that, well, you are really busy. You were really busy for the period of 27 days. You could not come to the court compound. You could not approach your lawyer. So para 10 says that the medical certificates of Fortis Hospital, Noida are filed herewith after entering them in a list of documents. You know, whenever a document is to be filed in the court, all the documents are to be entered in a list of documents to be prepared. So the appellant here also is filing medical certificates of his wife issued by Fortis Hospital, Noida to substantiate his sufficient cause for not filing appeal in time. Then this application has to be supported by an affidavit. We have learned drafting of affidavit in the last lecture. So an affidavit of the appellant in support of this application is also filed herewith. You are supposed to plead it, this factum also, in your application under section 5 of Limitation Act. Now the additional reason why your sufficient cause should be accepted, why your delay should be condoned, because the other party has also acquired a definite right by lapse of time, and the decree holder is happy that 30 days have expired, so my decree has become final. He is more than happy, but you are justifying your own cause. So you must mention that what is the loss to be caused to you if your appeal is not admitted, or if your application under section 5 of Limitation Act is not allowed. So you must mention this fact also while drafting an application under section 5 of Limitation Act. So this para says, if this application under section 5 Limitation Act is not allowed and appeal is not allowed to be filed, the appellant will suffer irreparable loss and injury which cannot be compensated in terms of money. You are saying that, sir, irreparable loss will be caused to me, irreparable injury will be caused to me if I am not allowed to file appeal, if my application under section 5 of Limitation Act is not allowed. You see, both the things will be filed simultaneously in the court. You will draft a memorandum of first appeal, and you will at the same time draft an application under section 5 of Limitation Act also. If your application under section 5 of Limitation Act is allowed, then hearing on admission of appeal will be made. But if your application under section 5 of Limitation Act is dismissed, then your appeal stands rejected because it is time barred. Lastly, you will make prayer. You have pleaded the facts, you have shown the documents, you have shown the sufficient cause, you have shown that you are likely to suffer irreparable loss and injuries. Now, what is your prayer? Prayer is, it is therefore most respectfully prayed that this application under section 5 of Limitation Act may kindly be allowed, and the delay in filing this appeal may kindly be condoned in the interest of justice, and appeal of the appellant may kindly be admitted and heard on merits. First of all, your application under section 5 will be decided. Once it is allowed, then whether appeal should be admitted or not, hearing will be done. And once the appeal is admitted, then of course both the parties will be heard on merits, whether appeal should be allowed or whether appeal should be dismissed. At the end of this application, the appellant has to put his signature, and the counsel ABC advocate will also sign this application under section 5 of Limitation Act, and it has to be duly dated. The date of filing is important because up to this date you will have to explain as to why the appeal was not filed up to 26th of August 2017. You must note down, I told you earlier also, that date of judgment and time utilized by the staff of the court in preparation of certified copies of the judgment and decree from 1st July to 15th July will be excluded from total period of 30 days fixed for filing appeal. This is provided in section 12 clause 2 of Limitation Act. And at the same time, the period of delay of 27 days, because appeal was to be filed on 30th July and it is now filed on 26th of August. So you will have to explain the delay from 30th July to 25th of August as to why your delay should be condoned under section 5 Limitation Act on the sufficient ground being shown. So dear students, this is first illustration of how to draft an application under section 5 of Limitation Act. And you have seen that the time for filing an appeal will start running from 2nd July. Because the date of judgment 1st July is to be excluded. So time has to run from 2nd July. And you know that limitation for filing appeal against judgment of lower court is 30 days, which is given in Article 116 of schedule attached to the Limitation Act. So these are the notes in the end so that you may see that your drafting is properly done and your drafting of an application under section 5 of Limitation Act is properly drafted and it is liable to be accepted before the court. Now dear students, let us take another illustration based on the same facts as to why and how the delay in filing appeal can be condoned. Heading will remain same, an application under section 5 of Limitation Act. The ground is sufficient ground to be shown for condonation of delay. Condonation of delay in filing appeal or revision. This section is not applicable to suits. That's why it is mentioned in the bracket. Please compare with suits. New suits, fresh suits, you cannot claim condonation of delay because you had sufficient time from the date of cause of action till filing of the suit. But in cases of appeals and applications, generally the period of limitation is either 15 days or 30 days. And for the High Court, it is maximum 90 days. And if you are filing further appeal before Supreme Court, again it is 30 days. So this period is a short period. Whereas the period for filing fresh suit was a longer one, 3 years, 6 years, or even 12 years. So there is no justification for further condonation of delay in filing the original suits. Hence, I told you that this section 5 of Limitation Act is not applicable to fresh suits. Now, while drafting a second illustration of the same application under section 5 of Limitation Act, first of all, the name of the court. Name of the court is First Appellate Court, because trial court is not possible because suits are to be filed before trial court, and section 5 is not applicable to fresh suits. So while drafting an application, you must remember that it can be trial court if you are moving some application, say your suit has been dismissed in default, you want to get it restored, or your suit has been decided ex parte, you want to move an application under Order 9, Rule 13 of CPC. or setting aside ex parte decree. So in those applications, name of the court will be the same, that is trial court, who has dismissed your suit in default or who has decreed the case ex parte. But if we are talking about the appeal, then the first line in the application again will be in the court of District Judge, Noida, District Gautam Buddha Nagar. Civil appeal number of 2017 will remain same. The name of the appellant is same, ASN of P, resident of 906 Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP. Versus the suit or appeal now is to be filed against the respondent. He is the defendant in the trial court. So opposite party is respondent. Center heading, as usual, as in the previous drafted application we have seen, center heading would be application under section 5 of Limitation Act for condonation of delay in filing this appeal. And the opening paragraph will be the appellant named above most respectfully submits as under. The first paragraph is that the appellant had filed a suit for specific performance of the contract before the London lower court, and the lower court was pleased to dismiss the original suit of the plaintiff on 1st July 2017. We have taken the illustration of specific performance of contract where the valuation of the suit was 1 crore rupees. So the trial court was Civil Judge Senior Division Noida. Now Civil Judge Senior Division Noida has dismissed the suit. Now the first appeal is to be filed before the court of District Judge. Now the appellant or the plaintiff appellant applied for certified copy of the judgment and decree passed against the plaintiff on 16 July 2017. Now see, this appellant is not that vigilant. He lost his case on 1st July, but he is applying for certified copies of the judgment and decree on 16 July. The said copies were delivered to plaintiff appellant on 25th July 2017. So see, this first period limitation which is to be counted from 2nd July, of course, the date of judgment is to be excluded. So period of limitation from 2nd July to 16th July will be lost. He has already consumed 15 days in the beginning. But the time taken by the office of the court in preparation of certified copies from 16th July to 25th July, it shall not be counted in the period of 30 days fixed for filing of appeal. Now, after obtaining the certified copies, the plaintiff appellant contacted his counsel and got the memorandum of appeal prepared. He instructed his counsel for filing of appeal, and the counsel has prepared the memorandum of appeal. And the counsel for appellant called him for signing the documents and filing of appeal on 1st August 2017. So 1st August 2017 means, well, the appeal, if filed on 1st August, will be well within limitation, because limitation is to be counted from 2nd of July, and period or the time consumed in obtaining certified copies is again to be excluded. The period of 10 days from 16 July to 25th July shall be excluded. So if appeal is filed on 1st August, it will be very well within limitation. There will be no problem. But what happened on 1st August 2017? What are the grounds as to why appeal was not filed in time? On 1st August 2017, the appellant was going to District Court Compound Noida, District Gautam Buddha Nagar by his motorbike. Yes, he is going to meet his counsel. He is very happy that today on 1st August, the appeal shall be filed in the court of District Judge Noida. But on the way, unfortunately, he met with an accident with a car, and the appellant fell down unconscious and was taken to Fortis Hospital, Noida by the members of the public. And see his hard luck. The hip bone of the appellant was broken and replaced by operation. And the appellant was released from hospital on 1st October 2017 after a period of 2 months. This is the sufficient cause which the appellant is showing before the court, that he could not file his appeal on 1st August because when he was going to court compound for filing an appeal, he met with an accident with a car and he was taken to the hospital. His hip bone was fractured and he was released from the hospital after 2 months. On 1st October, he was released from the hospital. Then, when he was released from hospital, see, same day he tried to approach his advocate. This fact you have to mention in your application, that the appellant somehow reached the office of his counsel, Mr. ABC Advocate, on 1st October itself and requested him to file appeal against the order and judgment dated 1st July, passed by the London Lower Court. And the applicant or the appellant signed all the documents as directed by his counsel, and accordingly appeal along with this application under section 5 of Limitation Act is being filed today. I told you that memorandum of appeal coupled with an application under section 5 of Limitation Act for condonation of delay are to be filed simultaneously. Now you have to justify your sufficient cause. And here the appellant says that the appellant has not committed any mistake intentionally in late filing of this appeal. He was prevented from filing this appeal before this honorable court because of reasons beyond his control on account of his accident. And the appellant was not in a position to move during the period from 1st August to 1st October on account of his illness and confinement to bed in the hospital. This is the reason which he is showing, and the reason is beyond his control. It appears, well, that reasons are beyond his control since he met with an accident. So what? Another adult member of his family could have filed this appeal, could have gone to the advocate, but he is pleading that there is no other adult member in the family of the appellant who could have taken care of filing this appeal. Now appellant says he has shown sufficient cause for not filing this appeal before this honorable court within a period of 30 days from the date of impugned judgment. You know what is impugned order or impugned judgment? That is order or judgment under challenge. The Civil Judge Senior Division, that is trial court, has dismissed your suit of specific performance of contract. So that order is an impugned order which you are going to challenge in this appeal. Now, what are the proofs? What is the evidence of your accident? What is the evidence of your illness? What is the evidence of your confinement to bed in the Fortis Hospital? You will have to mention. So para 10 says that the medical certificates of Fortis Hospital Noida are filed herewith after entering them in a list of documents. And as we have seen earlier also, that an affidavit is to be filed in support of application under section 5. So this factum you will have to mention, that an affidavit of the appellant in support of this application is also filed herewith. Now again, as we have learned earlier, that why your sufficient cause should be treated as sufficient and why your delay should be condoned, because the court has discretion not to accept your plea of sufficient cause. So you will have to mention in your application that if this application under section 5 Limitation Act is not allowed and appeal is not allowed to be filed, then appellant will suffer irreparable loss and injury which cannot be compensated in terms of money. This is the justification further which appellant is giving. Now lastly, the prayer. What do you want from the court? You want what? You are praying. It is therefore most respectfully prayed that this application under Section 5 of Limitation Act may kindly be allowed, and delay in filing this appeal may kindly be condoned in the interest of justice, and the appeal of appellant may kindly be admitted and heard on merits. This is the prayer which you want, that your application under Section 5 of Limitation Act should be allowed and your appeal may kindly be heard on merits. So the last portion of this application to be drafted is that appellant will put his signatures, and his counsel also, that is ABC advocate, will also sign this application. When date is to be mentioned, that is 1st October 2017. Why this date is important? Because till filing of this appeal, that is till 1st October 2017, a day before, that is 30th September 2017, you are supposed to explain delay of each and every day. We have seen earlier also that date of judgment is always excluded from the period fixed by law, and time taken in preparation of certified copies is also to be excluded in view of Section 12 Clause 2, and further period of 2 months from 1st August to 1st October may be excluded and condoned under Section 5 of Limitation Act if sufficient ground is shown to the court. You know that time for filing appeal starts running from 2nd July, because the date of judgment, that is 1st July, is to be excluded from reckoning the period of limitation. So this is how, dear students, the application under Section 5 of Limitation Act is to be drafted. To summarize that, this drafting incorporates few concepts of Limitation Act, which I told you in the earlier part of this lecture, that the Limitation Act is always applicable against the plaintiff only, and Limitation Act bars the remedy but not the right. Of course, there is one exception also, which is contained in Section 27 of the Indian Limitation Act, and as such, you know, the reason is that law favors only a vigilant litigant and not a litigant who sleeps over his rights. So the Limitation Act is drafted so that there may be end to the litigation. And as you know, once the one party winning the case, known as decree holder, he acquires a valuable right after lapse of time of filing appeal. So his right should not be lightheartedly taken, because his right is also important. And at the same time, if the appellant, like in present illustrations, met with an accident, remained in the Fortis hospital for 2 months, or unfortunately his wife also met with an accident when premature abortion case was there, so the appellant is also somewhere justified, but respondent's accrued right is also justified. So court has to strike out the balance between these two rights, and if the court thinks that the sufficient cause is being shown by the appellant and evidence is also filed in support of his sufficient cause, then court may in its discretion allow the application and condone the delay in filing of the appeal. Thank you very much, dear students.